Arbitrations normally ask who is right, but mediations ask for a far more enduring question. What is the right way forward? How to resolve the conflicts? In an era where commercial disputes have become increasingly complex, litigation and arbitration offer determined legal rights. Mediation, however, offers something that along with the or cannot always provide: understanding, collaborating, and durable resolutions. As an ancient profile Marathi saying, "Wat mitli ki nata tikto." When disputes are resolved, resolutions endure. Despite the enactment of Mediation Act and ladies and gentlemen, the chair, Honorable Justice Dangre, Shri S.G. Deshmukh, learned Judge Mr. Jaiswal, and Ms. Tanu Khatri. Please be seated. So I'll come back from where I was. Despite the enactment of Mediation Act and growing judicial encouragements, mediation remains one of the most underutilized mediation mechanism of dispute resolution in India. The challenge before us is therefore not merely legal, it is cultural. We must move from a mindset of contest to one of the consensus, from winning disputes to resolving them. Today's session brings together an exceptional panel comprising members of bench, experienced mediators, and seasoned practitioners, each of whom have contributed significantly to the strengthening India's mediation movement. To preside over this discussion, we are deeply honored to welcome Honorable Srimati Bharati Dangre, Madam. She is a judge of Bombay High Court. Justice Dangre has, throughout her distinguished career, exemplified the finest tradition of public service and judicial excellence. Before her elevation to the bench, her ladyship served with distinction as a government pleader at Nagpur bench of Bombay High Court, representing the state in a wide spectrum of constitutional, civil, criminal, and public law matters. Her extensive experience before Constitutional Court, coupled with her academic engagement and training as a mediator, has given her ladyship a rare perspective on both adjudicatory and consensual dispute resolution. Her judgment consistently reflects judicial balance, practical wisdom, and a deep commitment to ensure that justice remains both accessible and humane. We are truly privileged by her ladyship's gracious presence. May I respect all of you to kindly grace Justice Bharati Dangre by a great round of applause. May I request our panel members to kindly come forward for felicitating Justice Bharati Dangre. May I request Mr. Nilesh Pavaskar, Dr. Nilesh Pavaskar, and Mr. Bharat Gadkari to kindly come forward with a bouquet and a momentum. Thank you, Dr. Pavaskar. Thank you, Mr. Bharat. Moving forward to our speakers for the day, we have with us Shri S.G. Deshmukh. I will request my colleague Mansi Dande to come and introduce Shri Deshmukh.
Shri S.G. Deshmukh, sir, enrolled as an advocate in December 1978. A lecturer at KC College, Mumbai, and has also acted as AGP and additional PP. He is active in practice in Bombay High Court since 1982. A respected member of Bar whose professional experience and commitment to alternate dispute resolution have contributed significantly to promotion of mediation as an effective means. We are delighted to welcome you, sir. Please join me in extending a warm and respectful welcome to Shri S.G. Deshmukh, sir. Thank you.
May I request our colleagues Trishna Shah and Tanishka Chavan, along with Mr. Vinayak Shelar, to kindly come forward and felicitate Shri S.G. Deshmukh with a memento and a bouquet. The honor here is not only felicitating the senior most judge in mediation, but it is also because my volunteers, these are the team, we did the research and they are felicitating him. The next co-panelist that we have is a learned judge, Shri Kishor Jaiswal. He's a district judge at Maharashtra, senior trainer, mediation and conciliation project committee, Supreme Court of India. There are judges who decide cases. There are judges who teach others how disputes may never require adjudication at all. Shri Jaiswal belongs to that exceptional category. As a district judge and senior trainer on the panel of mediation and conciliation project committee of Honorable Supreme Court, he has successfully mediated thousands of disputes with an extraordinary settlement rate. He is an author of the acclaimed work Believe in Mediation, has represented India in international mediation forums, and has trained judges, lawyers, professionals across the country in the art and science of mediation. His works reminds us that the greatest judicial success is sometimes measured not by judgment delivered, but by disputes peacefully resolved. Sir has joined us all the way from Bhandardara, Nagpur, after fully attending his judicial work yesterday whole day, which was a working Saturday for him. Ladies and gentlemen, please join me in extending a warm welcome to Honorable Shri Kishor Deshwal. I will now request my volunteers, Dharini Jain, Mansi Dande, and Sarvesh Deshpande to kindly come forward and felicitate Shri Jaiswal. Ladies and gentlemen, may I have applause? May I now request Tanishka to kindly come and introduce our next speaker, Ms. Tanu Mehta.
Our next panelist, Ms. Tanu Mehta, has devoted nearly 3 decades to the practice of law as an advocate, mediator, arbitrator, conciliator, and a legal advisor. Impaneled with the Bombay High Court, the City Civil Court, and several leading mediation institutions across India, she has played an active role in advancing mediation both nationally and internationally. As a chairperson of the Committee for Mediation and Conciliation at the Bombay Chamber of Commerce and as a speaker at global mediation forums, Ms. Mehta has consistently demonstrated that a successful mediation is not merely a legal process. It is an exercise in communication, trust, and human understanding. Ladies and gentlemen, please join me in extending a warm and respectful welcome to Ms. Tanu Mehta.
Thank you, Tanishka. May I now request our volunteers, Shri Pratik Sabrad, Aniket Shitole, and Satyajit Salve to kindly come and felicitate I'm so sorry, Ms. Tanu Mehta. I think I've thrice said doctor. I hope that you become doctor quickly. You finish your PhD. Thank you so much. Justice delivered through adjudication resolves dispute. Justice achieved through dialogue often resolves people. If the arbitration teaches us value of legal certainty, mediation reminds us of value of human understanding. Discourage litigation, persuade your neighbor to compromise whenever you can. A famous said Abraham Lincoln quote. Perhaps that advice is even more relevant today than when it is first spoken. With great respect, I now request Justice Dangre to kindly assume the conduct of proceeding and invite our panelists to share their views.
The office bearers of AVI, the President, Dr. Mr. Relekar, the Secretary, Mr. Sabrad, all other office bearers, my co-panelist for today's session, and all the crowd which I see here, all the young generation and who are not so young, a very good morning. I say not so young because I consider myself to be young. So you can imagine all those who are above me, they are not so young, but definitely young. A very good morning to all of you. At the outset, I must really appreciate the efforts taken by AVI to conduct a conference on arbitration and mediation. I must say that arbitration, I have attended many conferences, of course, on the original side or from the Chamber of Commerce. There's a regular program being conducted for inculcating training in arbitration. And Mr. Mehta is there, his team is here, and I had an opportunity to participate in this program, at least for last 3-4 years, and I know how successful it is. That's why I want to applaud AVI for the fact that it has not only included arbitration, but also mediation in this conference. Arbitration is much spoken of. Arbitration has gained roots in this country. It's a different aspect that to what extent we are successful in the arbitration process, but undisputedly it is recognized as a most effective mode of alternate dispute resolution. And we see that big commercial disputes are settled via arbitration. In fact, in 1989, when the CPC is amended and ADRs were introduced for the purpose of having effective out-of-court settlement, at that time only, mediation was also introduced along with arbitration, mediation and conciliation. But you can see that it took us how many? More than 40 years. 2013, we came with an act of a Mediation Act. Why did it take so long for us? Because arbitration, of course, arbitration, there was 1940 Act, then there was 1996 Act, which was amended. Arbitration Act, you will see so many amendments taking place at every nook and corner when we realize the difficulties, bringing it in tune with the international standard. But mediation, it had to wait till 2013, to 2023, sorry, not 13 also, 2023. Are we not surprised? Because this was also a birth child of 1989, when 89A was amended. But then what took us so long? But it is also not that it has received a statutory recognition for the first time in 2023. But mediation definitely was in vogue. As far as our country is concerned, mediation is not something new. The first mediation, we all remember Lord Krishna mediating between Kauravas and Pandavas, trying to find out a resolve. And when it was not successful, we know what was the consequence. The consequence was ultimately war. A lot of destruction. Nobody thrived. Every generation was wiped out. That was the first case we talk of mediation in our ancient times. If you recollect, there were panchayats. They were known as pancha panchayats, that is comprising of 5 members. These were 5 neutral members. Whenever any dispute occurred in the village, the reference was made to this panchayat, and it used to be resolved. These were neutral persons who were not interested in both the parties, but after hearing both the sides, a resolve was. But of course, the difference was this, that whatever panchayat said, it was the final word. But ultimately, considering that these are the independent, impartial members, they are the elderly members of the society, their decision was respected. There was no appeal, end of it. But as the adjudicatory system was introduced in India, when the British came, this mode of mechanism of settlement in the villages it somehow got shadowed and did not shape up. Of course, when the Panchayat Raj was conceptualized, at that time it was expected that a bill was introduced, in fact, for resolving the disputes through Panchayat Raj, but that bill did not see the light of the day, and that's why probably it did not take up any statutory shape. So in this background, mediation was always with us, but and not only that, it did not receive a statutory recognition. Mediation was already introduced in 1989, and efforts were made to settle certain type of disputes through mediation. But unfortunately, all these years, we find that only a typical type of disputes or certain type of disputes are being referred to mediation. What are the choicest one? Matrimonial disputes. Because what was thought was that the parties coming together, making an attempt to resolve. Because you see, when mediation is not something, I must tell you, mediation is a very structured process. At the outset, I must tell you one thing, that when Mr. Sabrad and his team visited me and they told that we are having a mediation as a part of our conference. At the outset, I told them that we have attended, every year, I think twice, we have a conference on mediation. Kishor is a part of that conference. And every time I feel sorry to say, and I keep on complaining to Kishor, that hum kya kar rahe bhai? Har bar we are only talking of what is mediation, mediation, win-win situation for all. I said we have to come out of that now. Everybody knows what is mediation. What is the process of mediation? Mediation is resolving your dispute through a neutral umpire who is not interested in either of the parties. It is a structured procedure where the mediator because fortunately, I am also a trained mediator. And what a mediator is taught is you have to sit neutrally. You are not expected to take sides. You will first listen one party, listen to the other party. Then you will have a caucus where both the parties will come together. You will try to resolve the impasse which has now appeared through caucus. Then you will again have separate sessions and come at a conclusion. So this is what is mediation about. But that's what I told Mr. Sabrar, that we will not talk about what is mediation. Mediation, by this time, everybody is acquainted with mediation. Everybody knows what is mediation, how will mediation work. And in any case, our focus is now, with the enactment of 2023 Act, we need many, multifold number of mediators. So the focus of the Bar Association should be to train more and more mediators or create more and more mediators. And they can, of course, be the lawyers, young lawyers specifically, who are interested in doing this work, because it's very different from litigation. I must tell you that mediator necessarily when we'll hear about the experience from Kishor, as to mediator, you are not looking into the law points. I have some queries to put to Tanu also about what happens at the international level, because I had a talk with someone and I was told that it is completely different than what mediation process we are adapting. But for the time being, we will focus upon the fact that we are not going to discuss what is mediation. We are here to discuss why the mediation in this country, or specifically, I must say, in state of Maharashtra, has not taken up, gained a flight. We keep our ears and eyes open, and we always have a comparison with Delhi High Court, I think. Bombay High Court can only be compared with Delhi High Court. And in Delhi, when we come across the trained mediators or the judges, we come to know that the success rate is too high. In Kakkardoma mediation, they have a whole building which has a mediation center rather, they say that their success rate is 40%. So when we look at our rates, which we must concede that it's abysmally low, we wonder why. Now, therefore, I thought that we should have a discussion as to what is more required to have this, so that this moment gains a momentum. And specifically now, when it has a statutory backup. Initially, we had some rules framed, Bombay High Court had framed some rules. We had some do's and don'ts in mediation. We had some methodology, what type of cases to be referred to. But But is it that the type of cases that are being referred to mediation is the obstacle? Or is it the mindset of those people who come or who participate in this process only because the court says, okay, this is one stage, you go through it. It's only tick marking of the column what you say. That this, you have a checklist, this done, this done, this done, mediation is just one of them. We don't want mediation to be like this. Now, of course, in the Commercial Courts Act, you have seen that 12A, the Supreme Court has said that Patel Engineering, the Supreme Court has declared that the decision came first from Bombay High Court about the mandatory force, which is upheld by the Supreme Court in Patel Automotive. And now it is mandatory. But when I sit across the commercial jurisdiction, I see that people are coming here for, when there is a rejection of plaint under Order 7, Rule 11, for not going for mediation, people challenge that order. There are so many appeals which come before us saying that no, there is no need. They will spend 1 year here. The appeal not listed, we don't get time to hear, we take time to deliver. But they are not ready to go for mediation. They will say that no, there was an urgency, you waited here for 6 months, 1 year. But you don't want to follow that mandate. Or even if they want to follow the mandate, because it is imperative, the approach is that, oh, doesn't matter, one step and we'll go to the court then. So this is not a done thing. That's what we are here to discuss today, that where are we lacking? Or what is required to be done so that this becomes a success? Why is it successful in Delhi and not what in Bombay? Are that we are only referring the disputes of matrimonial nature, property disputes to mediation, and whether it cannot be successful in commercial? Bombay is a financial capital of the country. Why it should not be implemented in commercial matters? Because I always feel that like a matrimonial matter which causes an unrest in the society, so are commercial matters. And rather, I mean, from the bench, when you deal with some commercial matters, I still remember one big matter when it came before me, a family dispute. But when both senior counsels appearing on both sides, and immediately I said the father was claiming that he was some 85, 86-year-old. He wanted to remain as an MD. The son removed him. The son wanted to grab the chair. He said, I have given every facility to him except the name MD. He is entitled, his office is kept like that, his perks have remained like that, everything. But I want to sit in that chair. So I remember both senior counsels appeared before me and I indicated that I am not going to hear this matter at all. I said, why don't you sit together? I said, don't you realize this father has built the empire? So what's the point in for a few years? I said, I'm sorry to say, but his days are counted. May God give him a good life. But his days are counted and ultimately you are one or the other day, you are the only one who is going to be the successor of the chair. Then what stops you? And what he's saying, don't remove my name MD, because he was not coming to the office also. And both the senior counsels, they told me, all right, we'll come back to you. 1 date, 2 dates, and 3rd day they said, we have settled it. So this is not something which is not only possible in matrimonial matters, because what happens, what pains in a home is also what is equally applicable when you are not doing business at ease or you are in trouble. People are ready to settle rather in commercial matters, but only thing what happens is this, it's a fight of what you can say, fight of might. Oh, I am right. So if they go to some neutral person, we have on our panel of mediators, we have some people who are specifically engaged in commercial field. You have several entities who are best in commercial matters. They can be appointed as mediators, because now the new act has also introduced a concept of community mediation. These are some things where we will have to expand the scope of the process so that the act is really made a success. And though we have found that, I told you from 1989, it took us so many years till 2023 to bring a statutory amendment. Let's not wait for another 25 years to make this statute applicable. So these are my only introductory remarks, and we have very carefully chosen our panel from different facets. Advocate Deshmukh is the most successful mediator in Bombay High Court. I mean, I can speak only from Bombay, because whenever a matter is required to be referred for mediation, we only get two names from that side. One is senior counsel Mr. Rajiv Patil and one is Mr. Deshmukh. And we have seen that. Why? Because why? Now, therefore, we thought that we will have a mediator who is the most successful mediator, who can, in fact, we were also interested in inviting Dr. Rajiv Patil. For some reason, he was not available, because we want to know that what are that secrets, or what is that nub which this mediator feels, and why in other cases it may not yield to a success. See, ultimately, it's not that every mediation will become successful. We'll tell you that. We don't expect everything, because it's something which is really dependent upon the mindset of the parties. But it's the mediator-driven process. So it all depends upon how well the mediator handles this. We have Advocate Tanu Mehta, who has an experience of international media. Of course, she's an arbitrator also. She's all in one package, in fact. Arbitrator, mediator, and conciliator. But we want her today to share her experience on mediation. She has an international exposure, so we will also come to know what is that, what is there abroad, and what we are missing. Something is amiss, we must realize that. We have Mr. Jaiswal. I'll of course be referring him to as Kishor, because he is a trainer, and now a time has come that we have to encourage training in mediation, so that more and more of lawyers, because if you look at the scheme of the enactment, and if we tomorrow decide that every dispute must go to the mediator first, and then only it will land in the court, then definitely we are going to require more and more number of trained mediators. I'll tell you one thing, when I look at the panel of the mediators which we have for Bombay, Thane, Pune, and I find that largely ticking on trained mediators is very less. And I feel very sorry, because mediation is not something that I may see as you know that everybody is a mediator. In a family, when your children are fighting, when your neighbors are fighting, but sometimes you know what happens, sometimes if your neighbors are fighting, a trained person or a person with that mindset, he'll intervene, there'll be solace. Otherwise, he'll just flurry up the fight, and he'll be cause of the fight. So it's not that the quality is inherent. Whether some people may work out at it very peacefully. They may try to bring peace. But training of a person as a mediator is, and I'll tell you one thing, this is not only that, if you are a trained mediator, that will not only help you to act mediators before the court or court-appointed mediators, but there are various other societies. Why don't you, in your colony, in your societies, you have a panel of mediators prepared, some people nominated as mediators. Now you have gated colonies. A small dispute, every dispute land up before the court, FIR. Meri gaadi ke liye parking nahi diya, FIR. Then there's a civil suit. So can we not have these persons, trained mediators, can be very useful to bring a peaceful and harmonious atmosphere in the society. So though you may not act as mediators or may not be appointed as mediators by the court, of course you will get an opportunity, but even if the training is not going to waste. So with this background, we thought that we'll have three different perspectives of mediation, one from a lawyer's side, one from an international side, and one from a trainer's side, apart from the fact that our judicial officers themselves also indulge into mediation. So this is the wide canvas of our today's discussion. Now we'll discuss it, and of course you are rather encouraged to ask questions, because ultimately that is how we are going to move forward, by providing answers to the queries that are in your mind. Now may I request Mr. Deshmukh to share his experience at the beginning?
Yes, ma'am. Now the Honorable Chairperson, Justice Dangre, all my colleagues at the dais, and my friends. I consider myself very fortunate, as I am associated with the mediation from the day one when it started in the High Court. I don't remember the date, but I remember that Mr. Karachiwala gave us intensive training for about 2 days. We were about 35 to 40 advocates from original side and appellate side who attended that training. And from that day onwards, I have been associated with mediation till this date. Today's subject is actually why the mediation has not become extensive, or why it is underutilized, as it is said in the program. There are many reasons for that. Instead of that, I have been given a free hand, so instead of entering that area, I would like to share my own experiences, because I was looking for this opportunity so that the people would understand what I have been doing for last so many years. First of all, before entering that area, I would like to point out the basic distinction between the other modes of alternate dispute resolution, particularly arbitration. As I see, arbitration is to a great extent similar to conducting a suit or a civil trial in a court. Although it is, there are certain limitations and all that. Not as many appeals available for a civil suit are available in respect of arbitration. It is very difficult to set aside the arbitration award, etc. But still, recording of evidence, hearing arguments, cross-examination, everything is just like a civil suit. On the other hand, so far as mediation is concerned, it is altogether a different process. You see, as I understand, it should be kept away from law and legal niceties as far as possible. Because what is required is taking the parties into confidence, making them feel comfortable, making them open up so that you understand what is the real problem. That is the main thing. Then understanding their real problems, if they open up, then you really understand what is actually the problem. And then if it is reasonable, then to see what they expect, and if it is reasonable, to convince the other side to accept, or to a certain extent accept that. And then if it is not reasonable, to suggest some other alternative and to see whether both the parties agree to that. That is precisely what is required in a mediation, and it is distinct from arbitration. Now, so far as training is concerned, what I feel is that no formal training is going to help a mediator. Mediator has to train himself through his experience, how the people react to him, how they talk to him, how they open up to him, and on that basis he has to proceed further. Yes, so there is no formal, my learned friend is aware how the training goes on and all that, but from my experience I say that you have to train yourself through your own experience, that's right. Then, so far as I wanted to share my own experience with all of you, how I proceed with a mediation, and why to a certain extent I succeed in having a resolution between the parties. I basically, in the first sitting, or in the first session of the first sitting, I welcome all the persons, all the parties, the persons who accompany them, also their advocates and all that. Why it is necessary, so far as advocates are concerned, actually I feel that there is no role of the advocates so far as actual mediation is concerned. But the advocates are helpful to the extent that they can precisely tell you what is the stage of litigation, how far the parties have gone, and where the problem lies. So for that purpose, the presence of the advocate is necessary. So far as the persons accompanying or their relations which come with them, why their presence is necessary? Because ultimately the result of the mediation doesn't affect only the party. It affects his entire family, his or her entire family. And they also, therefore, should understand what is happening with their relation, what is happening in the mediation, whether he would get something or not. And not only that, in the process, they may help the party to arrive at a proper and correct decision. So for that purpose, I feel that the presence of the persons who are not formally parties to the suit, but who are related, also is necessary, and I welcome them in the first sitting. Then, initially, I always ask a question to the parties: do you know why you are here? Why you have been sent by the learned judge? Normally, the answer comes yes, for mediation. Then I ask them, do you know what is mediation? But then there is no very good answer to that. Then I let them understand that the learned judge who has sent you to me feels that you should not waste your time, that you should not unnecessarily waste your money, that you should not have mental pain anymore, and for that purpose you are sent here. What the judges expect is that you should talk freely to the mediator. Let the mediator understand your problem, and perhaps the mediator may suggest a proper solution for your problem, so that there could be something, and then thereafter, if both of you agree to something, it is an end of the litigation. There is nothing further. There is no appeal, nothing. And you will have your life for yourself thereafter. So then they understand. And I also let them understand that this is not a court. I am not going to pass any order. All that there is no recording of evidence. Whatever you say here will not be used anywhere, will not be recorded, and feel free to talk to me. Then only they open up and they try to tell us what is their real problem. Otherwise, no. Now, after this, my method is to talk to each of them, namely the parties, alone, and then they express themselves fully and properly. That is my experience. After hearing both the parties, I again call everybody who is present in the first session, and then on the basis of whatever I hear from the parties, I tell them that this appears to be the solution, this appears to be the solution, and please think about it. I also tell them if there is an alternative, and then I don't make them take a decision immediately. I tell them that please take your own time, think about it, think about what I am suggesting, think about whether you have any alternative to that, and then we'll have a further meeting, and then in that meeting we can decide what is to be done. I also make it clear that this not being a court, there is no order passed, and unless both of you agree to something, nothing is going to happen here. So everybody therefore becomes very free, and therefore they talk, they open their mind before you, and they talk, you really understand what is the problem. So that is how I proceed, and perhaps in the second or third meeting, because when the alternatives are given, then only the discussion is so far as those alternatives are concerned, and then we can reach the final solution, the final conclusion in any matter. This is how I proceed. I just wanted to share it with you because I wanted to know whether it is proper or it is okay and requires some, further improvement, or it is not okay. I wanted to share it with you for that purpose. But I must tell you, we started all this long back before the Act of 23 was enacted. But after going through the Act, I could realize that practically 90-95% of the Act proceeds on these lines only. Only so far as one of the sections, namely Section 21 of the Act, which speaks about the report of a mediator when the mediation fails. I have some doubt about that. Because what I feel is that it says that no, you should not give any reason why mediation failed. You should not say he has done this, he has not done this. I feel, I quite understand that the report should not contain anything which will affect the parties further in case the mediation fails and in case they are required to proceed further with the actual adjudication of their matter. So it should not contain something which will affect them. But the conduct of the parties in mediation perhaps could be relevant for the learned judge who receives the report and who thereafter has to proceed with the matter, because it may be of some use, some help to him. That is what I feel. And therefore, so far as Section 21 is concerned, I have my own doubts about that. Now, in following this method, initially, actually, I was not sure about how I should proceed with the mediation. But over the years, I saw that this should be precisely the method, and then it is so it doesn't waste my time. It doesn't waste the time of the parties also, and we can proceed smoothly. That is how I proceeded so far. Today, what I feel is that so far as this aspect of alternative dispute resolution is concerned, we have to also see the aspect of cost involved in that. Actually, so far as arbitration is concerned, the experience is that only big companies can afford that. A small litigant does not afford arbitration. That is the experience of each and every lawyer, as I understand. So far as mediation is concerned, it has to be as low as possible, because the persons involved in this, mediation may not be able to afford. Of course, there are some set rules regarding that. But what I feel, so far as I myself, many senior advocates, including Mr. Rajiv Patil and other senior advocates from the appellate side, also some senior advocates from the original side, they don't charge anything for mediation. I don't say that this should be the rule. What we feel is that we have earned sufficient from our profession. We owe certain duty to our profession, and this is one of them. We have to do something arising out of our profession and for the people at large, and therefore we do not charge. And I must say that I'm proud of all of us who do not charge for any mediation, although I don't feel that it is a condition, because if it is made a condition, the mediation may not grow. I understand. And therefore, one of the things we should keep in mind that the cost of alternative dispute resolution also is material, and it has to be considered there. Otherwise, the people may not afford it. The people may not be able to take it freely. That is how I feel about it. I think enough for the day. Thank you.
Thank you, Mr. Deshmukh. Two quick takes and one question. Is it that the young or not so young makes a difference when you act as a mediator? This is my first query. I mean, in a matrimonial matter, from a person like you, an experienced person, it makes a difference. But if tomorrow a 30-year-old girl is acting as a mediator, would it have the same impact is our question.
Actually,
Second,
yes.
that's a very pertinent question that comes to
Yes,
mind.
yes.
Does the age of the mediator makes a difference?
Actually, age makes a little difference, because you understand the world better as you age, go on aging. So
That I have started realizing now.
But actually, if you have a proper setup of your mind, then even a young mediator also can do a good work. There is no difficulty.
Second thing is, you talked about the report. The mediation failure report should not contain reasons. I personally feel that it is probably for the reason because when the matter comes, and if you see some prejudice in that report, then it may tend to have an influence on the judge who is deciding that matter. Because that's the confidentiality is the most salient feature of our mediation.
Yes.
Another thing is this, you said that you are doing it free. But we expect you not to do it free. because if you see abroad, when we had interactions in some conferences, when some mediators from US were present, we could see they are making rather than lawyers earning, there are firms in mediation, they make a huge earning. So let the mindset of general public also undergo a change, that if it is free, तो फिर क्या जाता है, जाके आ जाएंगे. I think that we should change.
No, I entirely agree with this.
Not that you are doing it pro bono. We appreciate your efforts.
Yes.
But something which comes free has no value is what our Indian sentiment is.
I entirely agree with this.
So now here and after, you may charge nominal, but let a person understand that who is sitting as a mediator is here because not that he is earning out of it, but his time is not free. He is devoting his time, it's not free. That's what I feel.
Yeah. But one thing is, the normal, you see, understanding or the normal mindset is that whatever is free has no value. But
So let's
But let me make it clear. I always make it very clear to the persons who come to me for mediation that if you are proceeding properly, you are attentive and all that, I have time for you to spend. But if you do not bother about mediation, I don't have time to waste.
Very good.
I make it very clear to them.
Yes. Now, may I call upon Tanu to share her experience? Because she has a wide international perspective also to the process of mediation.
Thank you, ma'am. Honorable Chair and all the honorable members on my dais and our dear friends and colleagues that I see across. Very interesting discussion already, and I think the questions that have been raised here require another perspective too, so I'm going to jump straight into another perspective that came from all the issues that were raised here. So, firstly, on this issue of whether a 30-year-old or a 25-year-old can mediate or not. So, so now we also have, young students who are training to be mediators and they are in their 20s. And of course, we have very experienced mediators. First of all, there is work for everybody because there is such a diversity of litigants and such a diversity of population, and there is all kinds that is required. What Mr. Deshmukh said, the process that he said, and very rightly so, all of us should be thinking what he is doing is what we call evaluative mediation, because he's giving suggestions, he's giving the options to the parties, saying this looks like a possible solution or these 4 options look like a possible solution. Now, of course, you know that our initial training, all of those who call ourselves trained mediators, the first training came from abroad, and abroad, of course, we were all taught facilitative training, including what MCPC teaches, that please don't give any suggestions, let the suggestions come from them. But again, as Indians, we have to develop our own systems. If evaluative works, because he is definitely the most successful mediator of Bombay High Court. So if that is the experience and if evaluative works, we should not be closed to evaluative mediation too. So eventually the mediator has to be, so alert to the parties and see what they are expecting. Are they very lost? Then allow the process of evaluative mediation to come into place. If they are already very expressive, very opinionated, they already have very strong ideas about how a solution looks like, let it be facilitative. So the first thing is that we should not close our minds to anything, and we should respect the experience that comes from all these very, very experienced mediators who've seen so much of mediation in their career that they know what is working for an Indian audience or an Indian litigant. And again, I will say all Indians are not the same. There will be people who will want suggestions. There will be people who will dislike your suggestions and have their own. So keep an open mind and let facilitative and evaluative both thrive together. So that's number one. Number two, on the issue of monetary compensation. So we are now definitely in a new generation, and world has also become very, very categorized. So to build professional mediation, it is important that there is professional money coming in. It was a different time, maybe 30 years ago, 40 years ago, when a person could be in litigation. I mean, one could go to court and one could still do other things. Now it's not possible. For example, I don't do litigation at all because it's not possible to find the time, and litigation has its own demands. You have to be in court at different times. You can be called at any times. So if we are going to have a set of professionals legally trained, but who are concentrating on mediation or arbitration or legal strategy, like you used to have earlier. You know, solicitors did not come into the court. Counsels came to the court. Similarly, now it's not just solicitors, counsels, there are mediators, the arbitrators, and everyone is really focusing on improving his or her craft day by day to ensure that maximum and optimal results come out. If that is the case, there's no scope for it being free, and it has to be paid for. So one of the things that even I wanted to answer in terms of another question that was raised by the very, very thorough team of Ms. Bansali. I think they did a fantastic job in creating a research paper and opening up certain questions, is that payment has to become a norm. And to free up the payment from what is already mentioned in the rules, let the payment be between the mediator and the parties. A mediator is smart enough to know what parties can pay, what they cannot pay. And if I am, for example, if I am being professionally paid for 10 mediations that I'm doing, and I see a case that's coming in where the parties are absolutely broke, I am going to do it pro bono. I mean, all of us have the intelligence. Even as lawyers, we do so many pro bono cases because it's our commitment. So there's no need for somebody else to say, oh, you will only take 5,000 in this, you will not take any money in this, you will take only 10,000. Leave that discretion, because give the benefit of doubt, that much intelligence the mediator has, that this party or this whole procedure is, here the parties are capable of this, so let it be a mutual discussion between the parties and the mediator. And whenever there is a doubt, let's say the mediator has not been able to gauge correctly, let it be then left to the judge. The mediation report can be sent to the judge with a clear line that no fees has been taken, and we will take whatever the judge decrees in their correct sense. So I think we should leave this, open this fetter. And that directly connects me to what ma'am asked earlier. What is the difference between doing international mediations and Indian mediations? And let me be clear, I'm not empaneled with any international forum. I'm empaneled with a lot of Indian forums, but then Indian forums also get international matters, naturally, because India is now at the forefront of the top 5 economies, and a lot of work, is with outsiders. So you do get mediations. And I have seen this. The fetter of an Indian empaneled institution is the fetter that the courts or the system has put in, saying that you cannot take more than this much money. That's put across all forums, right? If an institution has to be empaneled, whether it's a Bombay Chamber of Commerce, whether it's FICCI, whoever, when they are empaneled as a court empaneled mediator, then they are bound to follow what the court has already directed, that you will only be allowed to charge 5,000, 10,000, 15,000 or X percentage or whatever the court rules are. These fetters are not available with international mediation. So they leave that decision to the institution or to the good offices of the mediator, the discretion of the mediator to decide, all right, this party has come, what is the actual fee that ought to be taken. And once that is done, everything opens up.
We don't want to know from you about the fees. We want to know about the perspective of mediation in international this thing. I mean, fees, that's one aspect of it. But we want to know, how does international mediation, is the process different? Is the methodology adopted different?
Okay, so
Or
process.
Does it cover a wide range of subjects than we covered at domestic level? That's what we want to know from.
Right, so I'll answer all the three. Number one, the process definitely is more facilitative. But again, as I said, each country has to develop its own. China doesn't have a facilitative process at all. The China also has an ADR process. They don't have facilitative, they have evaluative. There are other countries which have very strict ideas about, even how a facilitative has to be. So I believe we should evolve our own mechanism, knowing that our people are this kind of people. And
Sorry to interrupt. I had happened to meet one Mr. Powell. He was from, I think, US. So what he told me was very surprising. He told that, of course, that's a complete firm into mediation. He told me that we get the whole papers. Now, in what mediation we do, we are told that the mediator will not even be handed over the brief. Yes. What he told was very surprising, that we are handed over the papers. So I go through the brief firstly, what is the stand of the plaintiff, what is the stand of the defendant. I study the law, and then with full focus on what is the facts, what is the law, I conduct the mediation proceedings. So he sometimes act as an, or I asked him that whether you act as an adjudicator. He said no, but when I'm conversant with the legal process and I know that what he can get and what he cannot get, or what the defendant is bound to give and what the plaintiff cannot get, he said I can put up and facilitate it in an open manner. Now I was just wondering that in a commercial matter, it's okay that you understand what's the pros and cons, in the sense what you are entitled. You say that there was a contract, so you know that in this contract, this part was enforceable, this was not enforceable. So I'll say that I'll be able to tell him that even if you go to the court of law, you are not otherwise going to get it, Baba, because this is against law. But in a matrimonial matter, the situation will be different. If I start reading the brief, then from the first page, what happened on the first time when the marriage was fixed, then how much they asked, then what the mother-in-law said, what happened on the first night. So if you get on reading, and then how one by one he drew me out of the house, how it took place. So am I not getting embroiled in that? So which is the correct method?
which is absolutely right, because we should not, I am in this favor, we should not be reading matrimonial briefs at all, because you tend to get
different, we can't have different parameters.
We have to, because
If mediation is a process, structured process, then in a court annex mediation, we don't give the brief to the mediator at all.
Yes. No. If I may correct, I call for a complete compilation before I enter mediation.
Okay. So
I also, to a certain extent, particularly the orders passed by earlier, I go through them, not the pleadings, etc. And I make it a point to keep at the back of my mind. So it never affects me when I talk to the party.
That's what I wanted to ask, to what extent?
Yes.
Because tell us in mediation training, that's strictly prohibited. Because I am a trained mediator. I remember I took my training somewhere in 2003 or 4. And we were told that you are not expected to look into the brief. You will not ask the parties, you will get it from the parties, what is coming.
Yes.
You will not encourage some solution, because as you said, it is facilitator. You can only drive the parties, but you will not say you do this. Or you, at the end of the caucus, if it comes that 1, 2, 3 are the option, you put all them to the parties and say that which is acceptable. I recollect sir saying that sometimes I call the parties. And suddenly what came to my mind was that as long as the husband and wife, it's okay. When the mother-in-law comes, then the whole thing goes out of, then though they are ready to come, the mother-in-law will have her own story to tell. and whether it really, so what should be the ideal scenario for a mediator? Of course, I had seen, Mr. Powell told me, I'm completely briefed, because then he knows you are asking for sky, but Baba, this is not possible for me to give in law.
yes.
Even if you go to the court, you will not give it. So he will rule out 1, 2, 3, 4. He'll tell the defendant that, oh, here you are, this is binding on you. You will have to pay. Even if you go to the court of law, you will have to pay these damages. Then I try to strike a balance that this is, according to law, you are entitled. This is your obligation. So then he told me that I drive a framework. So in India, possibly we are not doing this. So is it permissible to have this aspect of it to be considered in mediation, specifically commercial mediation?
I think in commercial mediations, the more complicated a matter is, the more important it is that you have your brief. Like Mr. Deshmukh says, keep it at the back of your mind, but you have to know things. Now let's say there's a maritime law matter. There are so many detailed things. When something goes wrong in a ship, it could be due to 100 reasons, and 100 reasons could be some very technical issues where, both parties, the parties who are fighting, whether it is the ship owner or the ship captain or whatever, it could have been beyond their control, because somebody with that mind has to recognize this was the chain of events, this is what happened. So commercial matters, definitely read them up, understand what it is, and therefore I would say, as a rule, we can actually start sending the whole brief. Let the mediator decide how much he wants to read, how much he wants to keep, what he doesn't want to. But let the brief be before the mediator.
Tanu, if we can just bring in Kishor. Yes. Kishor can tell us what we are, because he is a trainer. He knows what we teach in India. So let us go back to him.
Yes. Thank you. Thank you so much, Ladyship, Honorable Ladyship, Dangre Madam on the dais, my co-panelist, Deshmukh Sir, Tanu Madam, and Coordinator Bhansali Madam, and all the wonderful audience. A huge round of applause for all of you, looking so young and energetic. The best part of this panel is that our Honorable Chairperson herself has undergone 40 hours of intensive mediators training program under the aegis of Mediation and Conciliation Project Committee of Supreme Court. So a huge round of applause for Honorable Ladyship. You see, a very nice discussion is going on. First of all, let us revise ourselves as to why in section 89 itself there is such provision. You see, when the Arbitration Act was enacted in 1940, this section 89 was repealed, and from 1940 to 1999 this was a repealed provision, and amendment was carried out with a heading alternative dispute resolution mechanism like this, and from 2002 we are implementing it. So first of all, what I personally feel, and in this field as a trainer, there should be an attitudinal changes for all the 4 stakeholders. These 4 stakeholders are, first is litigant, for whom all we are here. And the second is, the second terms of litigant goes to advocate. Advocate then suggests and the matter comes to court. The third stakeholder becomes judge. And the fourth is mediator. So it's a teamwork. Why attitudinal changes is required for all stakeholders? Because if we see as an alternative dispute resolution mechanism, you will find that somewhere in some judgments you will find it is called as an additional dispute resolution mechanism. But my experience after conducting hundreds of matters, for some disputes like commercial dispute or matrimonial dispute, we should think it as if it is a appropriate dispute resolution mechanism. So unless and until if we start thinking in that way, we will not be in a position to make this beautiful process called as mediation a grand success. Let me share that in the state of Maharashtra, as compared to other states, good number of cases are being referred during this mediation 1.2 program, mediation for the nation, and 2.20 program, and we have 30% of success ratio. It's a good number. We are in fact 25 to 30% of success ratio in the state of Maharashtra. My experience is, if the matter is given to trained mediator and if the matter is given to untrained mediator, because we are having both mediators. I'm not saying that all untrained mediators are not performing well. The statistics reveals that the trained mediators are performance are better as compared to untrained mediators. So why training is required? Training is not only required to mediators but also to the honorable judges who are referring the matters. You see, role of referral judge is very important. As rightly pointed out by honorable ladyship that before the mediator there is nothing, only a referral order is there and only a copy of a plaint for knowing that who are the parties. So when the parties and advocates are there before the court and the judge before referring it for mediation from the dais explains within a minute or two as to what is the matter, how mediation is beneficial for them, how the mediation is going to be conducted. If he speaks for a few minutes with the litigant, interact with the litigants, we have seen that in at least in those matters, litigants attends the mediation session till the end. Failure or non-failure depends upon the mediator, but attending the mediation session or not attending the mediation session depends upon what advocate has said to the litigant and what the judge has written down in his referral order. Another thing which cannot be lost sight of is the FCON's case. It's a very important case because it has almost changed the scenario of looking towards mediation. FCON sometimes, you see, in the beginning, Honorable Ladyship has given us the example of Lord Shri Krishna. And if we looked into FCON's case, I always say that it may be called as Bhagavad Gita or a Bible or a Quran to understand as to how mediation is different from this other ADR modes. So instead, when we are on this mediation aspect, what is expected is a judge should mention the summary of the disputes in the referral order itself. If the summary of dispute is mentioned in the referral order, it gives an idea to mediator as to how old the dispute is, what is the nature of dispute and all these things. And if all signatures and mobile number and everything is being noted down in the referral order proper way, then the challenge which we are facing is that suppose if 100 matters are being referred, the statistic reveals that 40% of them are not attending the mediation session and the result is non-starter. I am not saying non-failure, because one or the other party has not attended. So the biggest challenge before we all and the stakeholders has to play a role there. At least even if FCON says that consent is not required of the parties, ascertaining willingness of the parties and their advocates who are representing should be there. So even signature of advocate should also have been obtained on the referral order. If this willingness is ascertained, then comes the role of a mediator. Now, if untrained mediator starts with the mediation, what I have observed is this. You see, I am saying all this from my experience at different levels. I am not on only urban cities perspective. I have traveled throughout India. I have been posted in the state of Maharashtra at remote places also. So the advocates who have not undergone this training, they start with the mediation directly. But a trained mediator generally starts with, he is introducing himself or herself, then taking introduction of the parties, and then the main role turns up of opening statement. This opening statement is very important because parties are not aware that this is a confidential patent. Parties are not aware that in what way they are going to do it. Parties are not aware how much time they are having because rules provide there is limitation that 60 days and 90 days, all these rules are there. And parties are not aware that if requires, the mediator is going to have a caucus or a private or individual session with the parties. If without knowing all this thing, at one point of time, if you say to advocate or a party, you stay out and want to speak with a party, so it is a sudden surprise for them. My experience is if an opening statement or introduction is better, you see Aristotle has rightly said, well begun is half done. So on the day first, if the mediator gives his opening statement, his introduction, the mediation works in far better way. And the purpose of joint session is to gather information because he don't have anything with him. How that joint session is to be carried out, what skills the mediator should apply, that is listening skills, communication skills. If he is an untrained mediator, no doubt, lawyers are a good speakers, lawyers are a good listener, but It is on our mind that we are a good listener. But if the mediator is listening, he should be an active listener. Active listener in the sense, he should be in a position to understand what the parties are saying and what the parties have not said. Not said he can understand only when he is aware of body language. You see, in mediation room, how is your sitting arrangement? How the mediator is sitting? Whether he is maintaining his solar position, straight shoulder, open posture, leaning forward towards speaker, maintaining eye contact with the parties, relaxed but alert. Your small thing, how is your sitting arrangement in a mediation room or where you have taken your mediation, gives a greater impact on the parties. If they are not comfortable, facilitator, we say, but unless the mediator creates a conducive atmosphere, parties doesn't open up. It's very difficult to ascertain confidential information of the parties from, you see, no one discloses their very confidential information to anyone unless and until he feels that he is your friend. So mediator act as a catalyst, mediator act as a friend. And I do not agree with one of the co-panelists saying that the mediator can give suggestion. To my mind, if the mediator starts giving suggestion to parties, he steps into the shoes of conciliator. Conciliator plays an active role in mediation. In fact, the role of mediator is to generate options from the, to create options from the parties, to generate options, and then to evaluate those options, which is the best option for the parties to resolve their dispute. Then, the importance of single session. Many matters which has resulted in non-settlement, I have asked the mediator, how you have done it? Have you taken single session? So he said no. You see, the beauty of this mediation is complete process is confidential, but inside this complete process, the single session or a private session or a caucus, it is also confidential because whatever information is disclosed in this caucus cannot be disclosed to other party without obtaining the consent. So this is lacking, and what we have experienced is that when single session is not being taken, the parties don't open up. You see, I have dealt with several matters. My experience is, and you will not believe, 10% whatever cases they have filed before the court or whatever positions the parties have taken before the court of law, in fact, what is their interest and need is never pleaded, and it cannot be pleaded. It can only be gathered in this confidential session. So position is as if it is a tip of an iceberg, which is being filed in the courts of law. What is the underlying interest can only be gathered in the confidential session. So the main, unless and until mediator is in a position to understand the conflict, in simple way, my experience says that what is conflict? Conflict is nothing but a byproduct of ego and mind. It's a byproduct of ego and mind. And if mediator fails to understand the real conflict between the parties, he will not be in a position to take the parties to their resolution. And at the end, the parties should feel that that this is their own, because this process, according to me, has given pen, paper and ink to consumer of justice to write their own judgment. And they should feel at the time of writing a settlement agreement that yes, we have come to. So sometimes at any stage an impasse comes during this mediation session. And again I have asked some of the mediators, ते काय म्हणतात की काहीच there was no progress. दोन्ही पार्टी एका याच्यात स्ट्रक झाली. So what has happened? You see, mediator should also be aware of psychology and basically human psychology. The basic mistake which generally mediators comes is that they do bargaining aspect in a joint session. You see, human psychology is that suppose if A is sitting, B is sitting, A has given an offer that he is ready to pay rupees 50,000 to B, B will never accept it. Because B now knows that A is ready to pay me 50,000 and he will expect that I can gather more and more, I can extract more and more money from. But if this is going on in single session, A has told to me that I am ready to give 50,000. I have obtained consent of A whether I should communicate it to B. So my communication with the B, if I directly say to her that A is ready to pay rupees 50,000, B will never agree. But if I say, will you be satisfied with rupees 50,000? So the B will have a human psychology ki no, not yet, A has not given, not yet, but mediator is trying for this. So this human psychology aspect, my experience is that mediator should use caucus as many as till the parties come within the zone of potential agreement. And the basic mistake with the mediator commits is that they do all this in joint session and therefore it results in non-settlement. So,
Kishor, can I stop
yes,
you now
yes.
because the learned judge is there. So what is the takeaway from your recourse is this? First is gaining confidence.
Yes.
Gaining confidence by the parties and ensuring that there will be confidentiality. So confidence and confidentiality, these two C's will be very important
Yes.
in mediation. One query I have is this. You said that there are non-starter cases. Now, do you by any means suggest that, like we have made mediation compulsory in the Commercial Courts Act, do we have a methodology where every case, for example, at least the matrimonial matters, now commercial cases so important, mediation is made compulsory or imperative? Will it help that if we make it that every matrimonial matter must go to mediator first?
Yes.
Because ultimately, sometimes we see when the matter comes in our lap in High Court level also, we have to call the parties in chamber, make an attempt for settlement. So first is this, whether this should be made compulsory for every matter so that the non-starter and not cooperating lawyers not come in, will be able to do away with that. And you have not yet answered one of my query, the first thing that whether a brief should be handed over, because what Tanu and Mr. Deshmukh has said, that he should be at least knowing the background. But since I have taken the training and you are a trainer, the first brief what we give during mediation is this: he is not entitled to, he should start on a clean slate. The mediator shall not have anything. He will extract in from the parties only. What the parties tell him, then they start, maybe that they start, bargaining right from, not bargaining, but it is you are lending your ears to them. So sometimes it comes as first session you will find that a lot of outbursts. In caucus also, when you see in the caucus, when they come together, then it's again a mess because everyone wants to speak. So whether this methodology, what is adopted abroad, that a mediator is well prepared with the matter, of course to what extent he should use that information is the skill of a mediator. But in the back of mind, as Mr. Deshmukh has said, that in the back of the mind he knows where is the nub or where the shoe is pinching. So is it all right that if we adopt this mechanism of the mediator being aware of the actual facts from the papers which are there?
Very interesting question Honorable Ladyship has put. The first and foremost thing is that even if we are judges or advocates, we are very judgmental. Judgmental in the sense, if we will go through the case papers, we will be in our mind, no, this is the case, now this is this demand, the law says like this, law says like this.
We will be judging in that case.
Judging it. So,
adjudicating, not mediating.
Not mediating. So the mediator should be non-judgmental. But only one thing is that even if record or papers are not there before the mediator, the rule says so that with consent of parties and their advocates, say for particular document, if it is required to be discussed, with permission of a court, if the coordinator is a judicial officer, then with permission, the record can be called for. And only if both parties consent. That is what rule says so. And
May I say something about that? You see, when I go through the papers, I don't go through the pleadings. Because as I understand, pleadings are to a great extent creation of the lawyers. No, let us be clear about that. And therefore, actually what the party has to say may not be reflected in the pleadings at all. Therefore, the idea is to understand the parties. Therefore, pleading, etc. are not very relevant.
Not with the viewpoint of judging, but to understanding what is the background in which the matter has come to.
Precisely. And one thing I could not, Tanu was saying, that it was my mistake, I did not make it clear. After the discussion is over with the parties individually, I ask the parties, what do you expect to happen? And it is only thereafter I make some suggestion. It is not as if I put my suggestion on them immediately. Initially, I take it from them. And if it is reasonable, I put it to the other side. And if they have something different in their mind, then I put my suggestion to them.
So that's what Kishor has said, that I put it to other side, I take it from one party, that his offer is 5 lakhs. You ask the other party, what is your expectation?
That's right.
Then if he says that, no, my expectation is 6 lakh, you don't put it directly like a bargaining, but you try to persuade side A that, is it not proper that instead of 5, you go a little up? You try to tell B that, can you not come up to 530, and that's how the solution will emerge on its own. And I think we have rightly appreciated that this is the beauty of the mediation process, letting the parties arrive at a solution on their own with the help of a mediator who is a neutral person. So I think it has emerged from the discussion with clarity that why we are not getting into the whole brief, because a mediator is not judging. A mediator is not adjudicating. He is trying to fill the nub of the dispute between the parties, and then rather not trying, he is permitting the parties to come to a solution on his own, on their own. He is only facilitating. So I think from today's discussion, the takeaway is that a judge is not a mediator is not a judge. Second thing is this, he will only assist the parties, and that's what even the Mediation Act says. And this is what is the principle of mediation which has been followed. Lord Krishna did not tell either of the parties that you do this or you do that. In fact, he was within his powers to do that. But he tried to suggest, can you just give these villages? When the refusal came, he gave another suggestion. But ultimately, he never forced the decision. So this is what we'll have to understand. Ultimately, when you are given the training for mediation, of course, what Mr. Deshmukh has said is absolutely right. Training for the purpose that it is a structured process. It is not a haphazard process. As Kishor has said, that when the parties are introduced, they should be told, because when the husband and wife come, they don't know what is mediation. They say that baki kisi ke paas bheja hai, jaise bheja hai, so I tell, he tell, that's it. You have to walk out. But you have to tell them that, see, I'm trying to understand. You will have to come a solution. See, it gives a lot of, it will create a different scenario when you tell the parties that I am not here to suggest anything to you. You have to come out. You tell me your problem. I'll also hear his problem. And then maybe you together can come to a solution. I will only assist you. I think that will change the whole composition or the whole texture of mediation. This is what we are taught in the mediation training. It's a 40 hours training, then there is of course an advanced training also. But I think all of you, rather the Bar Association is also trying its level best to have this 40 hours training. And as I told you in the opening itself, it may not be that only for the court-assisted mediation, you may be mediators, but you can be mediators in other forms also. One clarification and then we'll end up the session. As Tanu has said that let it be left to the mediators to decide the fees. But we must make it clear that as far as the court annex mediations are concerned, like even for arbitration, you have the schedule of fees. So for court-assisted mediations, at this stage, we are not mature enough to leave the mediator to determine his own fees. Of course, when you have private institutions or institutional mediation, they can determine their fees. But for court-assisted mediations, we will definitely have a schedule of fees, and that is probably per sitting. It is not also dependent upon the outcome, but how many sittings you have. So for the time being, let us be happy with this, that at least the mediators are not that they want to earn, but they are paid for what great services they are rendering. I think we had a wonderful discussion and we should come to an end because Justice Marne and Mr. Godbole are here for the next session. So thank you very much. Thank you for being patient. Yes, only one or two, because the problem is this, we have another session and we have the CJI's address at 1 p.m.
Yeah.
Hello. Please give him the mic. There are only 2 questions, 1 and 2, and then one we have over here, and I think we'll have to wind up, but we'll just try to do that. Yes.
Ladyship, I am Advocate Ayaz Fazal Boy. I would like to ask the question to Justice Kishor Jaiswal, sir. Please, can you guide me regarding ZOPA,
Yes.
that is Zone of Possible
Agreement. Yes.
Did you mentioned it, sir? So you know that it comes after to Batna and Watna.
Yes.
Now the question I'm asking, in your experience, since you are having this MCPC training, this issue comes, there is no ZOPA. Let us start with this initial problem. Because they are fighting, am I right, sir?
Yes, sir.
They are fighting in court. Whatever it is, matrimonial, family, property, commercial. If they are fighting, they have been advised, they have a good chance. So if there is no ZOPA, the Batna he has a good chance in court, and that's why there is no ZOPA. Another question, how do you create the ZOPA in a specific instance in family matters? I'll tell you why, sir. Matrimonial, there is an issue, but in family matters, the mostly property division connected. So partition suits, etc. In this issue, the properties are jumping up every day. So they have a good chance.
Okay.
This is the question.
Okay.
If you can advise how to
Yes.
create, and in your experience, how you have done it.
Okay.
Thank you.
Very, very interesting question put by this sir. Ki how in matrimonial dispute or other disputes we can come to know that the parties are within the zone of potential agreement. First of all, my experience is that I am a mediator who make maximum use of caucus session. And once I have decided to be on a caucus session, I never switch to again joint session unless the parties come within that ZOPA. And while in caucus session, we can have a sub-caucus or sub-caucus session. So in the query put by this sir, generally in matrimonial dispute, I make a use of reality testing technique. Reality testing means making them aware of if the parties are not going to settle the dispute here on a mediation table, what are the other possibilities of in future, what will happen of there. So reality testing, and second, which I generally use to understand whether the parties are in the ZOPA or not, is a brainstorming technique. It means if several options are there available before the parties, to evaluate one by one each and every topic-wise options, and then to evaluate which will be the best option for them. So and the third thing is that if we are in the field of a law and we are judges or we are advocates, generally our thinking is very logical thinking. But when we are there on a mediation table or a mediator, we have to take the parties towards lateral thinking. I mean, thinking out of box. What is there? If we are trying to resolve the dispute within 4 corners, generally it doesn't happen. But if we make use of lateral thinking techniques, sir, these 3 techniques, reality testing, brainstorming and lateral thinking, helps to understand whether the parties are come within the zone of potential agreement, and then we switch over and try to settle the dispute.
Thank you so much, sir.